Hi, everyone. My name is Marie-Yves Nadine Jean-Baptiste, and I'm the owner and CEO of the St. Eve Law Firm located here in Towson. Thank you so much for joining us today, and welcome to Let's Talk, where we discuss updates to the law pertaining to estates and trusts and the area of taxation. So today I wanted to talk to you about some changes in the law that are happening. It's many, many changes, but realistically, I can't focus on every single one of them. So each week, we are going to bring you different areas of the law and any changes that may occur and how it may pertain to you, right? So for individuals who unfortunately have had a situation where a loved one has passed away, you have to deal with the Register of Wills. Every single county in the state of Maryland has one. Our firm has dealt with almost all of the Register of Wills in the entire state of Maryland. These individuals, composed of different clerks and different admins that are there to guide you through the probate process in the event you don't have an attorney. However, in cases where our firm is involved, we have formed a really great partnership with all of the individuals who are available to pretty much just answer our questions. And in that case, the Register of Wills I don't want to say pretty much, but their main purpose is to not only administer, the probate process, but we also utilize them in order to store wills. So when a client comes in and we prepare a will for them, we take it upon ourselves to make sure that the will is stored in the county in which the person resides. So that way, in the event anything happens in the future, we just retrieve the will and we can start the whole probate process if there is an estate to probate. So today I wanted to talk to you about the changes to the Estates and Trust Articles section 2-206. Under this section, it talks about different fees that the Register of Wills is allowed to collect, right? So when you're probating an estate, whether as a personal representative or as an attorney who is assisting a personal representative, or you're the personal representative and the attorney, as it is the case in some of the cases that I have, you will be faced with having to pay certain administrative costs. So under this rule, it outlines certain costs that the registrar has to collect when administering estates for individuals residing in the state of Maryland. So one of the most notable changes is that the register is required to basically collect these fees prior to even recording any document. So for example, if I'm closing an estate and I file what's called an accounting, the accounting is a breakdown of everything that has come in and everything that has gone out and who's getting what, really. It's not as simple as I made it sound, but just for the efficiency of the time that we have today, that's the synopsis I'm going to use. But nevertheless, when you file the accounting, you can either file an interim accounting, which tells the court, hey, we're not done yet. We still have a couple of things that need to be taken care of, and we're going to hold on to whatever estate property is here. Or you can file what I usually file is a first and final or second and final, just a final accounting. Now, the final accounting tells the Register of Wills that the case is done. We are ready to distribute the money. We just need you to say when. And in this case, you also have to provide the register with a check for the probate fee. The probate fee is based on a scale that the court has implemented in order to continue its operations, right? It gets paid for the services that it provides. So in the changes under 2-206, the register is now required to take these fees from you prior to even recording any document that you've provided, meaning it's as if you haven't done anything unless you've actually provided payment, right? Now, in that same token, there are situations where that fee can easily be waived. So the criteria is that the property is located in the state of Maryland. So if you have a house the house has to be located and situated in the state of Maryland. The property that is being transferred has to have an heir to the estate. An heir is the person to whom either money has been left through a will, or if there is no will, our laws allow that person to inherit the individual's property, right? So the court will waive the fees if the property is in estate, the property that's being transferred has an heir who is currently residing in it, and, or there's a lien on the property, right? So you have to look at your specific circumstance as an heir or as a personal representative to determine whether any of this actually pertains to you, right? Again, I'm not going to go through the whole law. I have 7 pages here. I don't think we have time for that, but I kind of just wanted to give everyone just a brief overview of, some of the important changes I think are taking place in this article, especially one that, affects our clients' cases. And I think it's very important for any individual who, will have, who is tasked with administering an estate. Another notable change, I think, is the changes to the fees, the probate fee. Usually, the probate fees goes up to a maximum of the estate can go up to a maximum of $5 million, and there's a set formula that is used. It's $2,500 plus the excess of a certain percentage over that, right? Lots of math. I didn't go to law school for math, but what I think is very important is that probate, the probate estate amount has actually been expanded. So now it's up to 10 million. And if it's over that 10 million amount, then you're looking at a $10,000 base probate fee plus 0.02% of the excess, right? So that's a lot of fees. But ultimately, it's better for you to be informed to go in knowing that although you have X amount of dollars in the estate account, not all of that is going to go to the beneficiaries or their charities or anything like that. Some of it will actually have to go to the Register of Wills for it to continue its operation. Now, another notable change is prior to, and I didn't realize, so this is House Bill 766-21 for anyone who is, or rather House Bill 187, for anyone who wants to go and take a look at this, you can go ahead and look it up. The good news is we will have the link to the House Bill in the, on the website. You can check it out at saintevelaw.com. And we will have all the links. We will have the text for easy reference. And, it's very readable, I think. This is one of those very few areas in the law that is readable. But anyway, so the probate fee for estates under $50,000 used to be $50. Now for probate estates, so now that fee is actually $0, which I think is pretty cool. But as you go further down that chart, you're looking at, for estates that are $100,000, you're looking at $100 and so forth and so on. So for smaller estates, the fee can be a little significant, especially in situations where there's just not enough money to actually take care of these fees. But the good news is that under the under 2-206, there is a small estate. You can actually transfer an estate you initially thought was a larger estate over $100,000 to a smaller estate, over $50,000 to a smaller estate under $50,000. And in that case, you're looking at not having to actually even pay fees, right? So that's really good. The register, another change is the register may not receive fees in connection where there is a small estate where the surviving spouse is the sole heir, right? So that means no children, no one left anything to, Uncle Bob and Cousin Jack. It's just the spouse is Either under the law or under the will, the spouse is the only legatee. And in that case, if the property is also under $100,000 that is being left to the sole spouse, then yes, you are looking at a situation where there's no fee, which is really good, right? Because in most situations, at least in my experience, where you have spouses who have lost their significant other and they went from being a dual income household to a single income household, any dollar that comes in, right, it matters. It just matters. So with that said, that's kind of just a brief synopsis on some of the changes to this section. If you want to go to the stlaw.com, again, we will have the bill. We will have a blog post with a brief synopsis of some other changes that are taking place. And I think this is a really good read for individuals who are either in the process of starting the probate, the probate journey, or individuals who are even just thinking, okay, I want to do an estate plan, but it's going to go through probate. How do I plan for, these fees? Because it's not just the probate fee, right? It's fees for copies, fees for certified documents, just fees for the bond. I have clients where a lot of them do not anticipate that there will be a fee for bond. Depending on their situation, you might be looking at a personal representative bond, which is very high depending on the estate, or a nominal bond. A nominal bond can range anywhere between $100 to $150. So as you go, in addition to attorney's fees, as you go, these fees tend to get a little higher. So I think this is something else that is imperative for us as practitioners to kind of just help our clients, think about and navigate when they're doing their estate plans, right? So with that said, again, these links will be on the website. There will be a hearing, before I forget, there will be a hearing on the amendments to Section 2-206 of the Estates and Trust article on March 29th at, it looks like 1 p.m. So keep in mind, there will be most likely more changes. This is the law, right? Very fluid. And so you might want to look out for those changes after March 29th. If any of you out there are consulting with attorneys, maybe you want to, you might want to bring this up. You might want to talk about the possible fees and how they will affect you. The good news is the law is not retroactive, right? It only applies to estates that are coming up in the future. And for us Marylanders out there, we all know that the law is actually going to effect in October. So thankfully, we got about 7 months before these laws are effective, but ultimately, it's always good to be in the know. With that said, that's all for today on Let's Talk. I am your host, Marie-Yves Nadine Jean-Baptiste. Please follow and subscribe to St. Eve Law Firm. We are on all social media outlets. I always have to take a pause and try to remember because, yeah, we're on a lot of outlets, Facebook, Instagram, YouTube, Twitter, TikTok. If you want to hit us up at info, I-N-F-O, at stlaw.com, please go ahead and send us your questions. If you have any questions that you would like for me to bring up, if you would like for me to answer at the, at the next event, we will be airing this program. Today is the first episode. I am honored to be here today. And my friend Tanae is commenting. She is also an attorney. She is also an estate planning attorney. So she loves what I do and I love what she does. And, we collaborate a lot on some things. Thank you, Tanae. But anyway, it's been a pleasure, everyone. I am your host, Marie-Yves. Thank you and have a beautiful, beautiful day. Bye.